Any person who is transferring property to another person must have capacity to affect that transfer.
Most people think that capacity is something to do with ageing and developing degenerative diseases. Many people will lose capacity, sometimes temporarily. What if you're in the middle of selling their house? Who's going to act for them then? We advocate in favour very much of having lasting powers of attorney for every client.
Capacity has a number of meanings. It can be a loss of mental capacity. Equally, it can be legal capacity, including personality disorders, loss of judgment, loss of free will.
Where we have issues of addiction, that can become incredibly delicate.
The victim is always the most powerful person in the room. Even though somebody's clean of substance, you can still have the behavior associated with an addict. Educate yourselves about addiction.
There's more and more recognition of the insidious nature of coercive control. It's now a criminal offence.
If trustees have concerns that a settlor might be vulnerable but has capacity, they still need to take steps to make sure the settlor isn't being taken advantage of.
Sometimes trust instruments include a definition of incapacity. It lists a number of events that are deemed to be incapacitating, and when they arise, the person in question relinquishes the office that they hold. A successor is appointed to that office in their place. What one sees in the Pugachev trusts is a very wide definition of incapacity, including detention, inability to exercise free will, the inability of the trustees to locate him for a period of time. The creditors of Mr. Pugachev, seeking to enforce against the trust assets, obtain a freezing injunction from the High Court in London. That is an incapacitating event. It's found that it interferes with his ability to act as protector, so that triggers the appointment of a successor.
Trust deeds will often contain now, and have done for a while, a definition of incommunicado. It allows the trustees to continue to operate the trust without the involvement of that individual. Where you haven't got those provisions, the only option then is to seek directions from a local court.
Discussions around the settlor, power holders and beneficiaries losing capacity probably wasn't at the forefront of everyone's mind 30 or 40 years ago.
Creators of wealth are often confident people, very well educated people, often very intuitive. Some of the early warning signs can be very worrying for the family, but as trustee you might not even see that. You may get somebody who can actually just have that meeting with you a couple of times a year, particularly if it's not in person, and mask effectively their diminishing capacity.
Someone might have become very successful forging their own path, and that can make it very difficult to spot impairment as opposed to flashes of genius.
When you've had a lot of division in a family, you start to get the split reinforced by lawyers, accountants, and that's when the power struggle starts.
One of the challenges for a trustee is to start to introduce to conversations with the settlor a check on capacity. And in that context, a family office can be really useful. Who can say, look, the settlor now has good days and bad days.
It is important that you put in place a structure that has sufficient flexibility to cope with changes in the future.
You've got to be prepared to do the intervention.